Welcome to our press conference at the Foreign Correspondents Club. My name is Teddy Jimbo. I'm a co-chairman of the committee that organizes all the media events and like this one. And I'm your moderator today. And our speaker is a kind of frequent speaker here. I think it's fair to say, Nobuo Gohara. He's a lawyer and he's a former prosecutor. And our interpreter is Seth Reams on my far right. And as the notice distributed to you explains, Gohara-san will talk about the recent, I would say, incidents in which foreign corporate executives working for Japanese corporations have been arrested one after another. Of course, the most prominent ones are Carlos Ghosn and Greg Kelly, but also another two executives from the Nikko Smbc Securities who were also arrested. And Gohara-san is concerned that the prosecutors and the Securities and Exchange Surveillance Commission have some sort of ill intent, or I might say, in arresting those people. And he will explain why those cases are problematic and what are the possible intent or the background of these arrest targeting the foreign executives. Gohara-san will speak about 20 to half an hour. He will have to speak about two cases. So I asked him for 20 minutes, but he wants to. He said it might take about half an hour or so, and I will try to take as many questions as possible, starting from the people who are here in person, and then we will try to pick up the questions from online as much as possible. じゃあ、小原さんよろしくお願いいたします。はい。
ご紹介いただきました弁護士の郷原です。よろしくお願いいたします。2018年11月19日、日産自動車のカルロス・ゴーン会長とグレッグ・ケリー代表取締役が禁止法違反容疑で東京地検特捜部に逮捕されました。その年の12月にゴーン氏、日産とともに起訴されたケリー氏は、その後、保釈中のゴーン氏がレバノンに逃亡したため、一人日本に残されて裁判が続き、逮捕から3年半を経過した今年3月4日に判決が言い渡されました。一方、はい。
Good morning, everybody. My name is Gohara, and I'm an attorney. Thank you for hosting me today. I'd like to start my remarks. On November 19th, 2018, the Nissan Motor Chairman Carlos Ghosn and Representative Director Greg Kelly were arrested by the Special Investigation Division of Tokyo Public Prosecutor's Office on charges of violating the Financial Instruments and Exchange Act. In December of the same year, Mr. Kelly, who had been indicted along with Nissan and Mr. Ghosn, and was left behind in Japan, essentially, because afterward, Mr. Ghosn, who had been released on bail, fled to Lebanon. He remained for 3.5 years until finally, in March 4th of this year, 2022, he was handed down a verdict on March 4th.
そして、証券取引等監視委員会が強制調査を行い、これを受けて東京地検特捜部が捜査に乗り出した Smbc 日興証券の相場操縦事件で、同社の外国人幹部、トレボ・ヒル氏、アレックス・アバギャンツ氏の2人が逮捕・起訴されました。この2つの事件は、ゴーン氏の公金について、国際人権理事会恣意的公金作業部会で厳しく批判されたことにも表れた日本の刑事司法の全近代性が 端的に現れたものだと言えます。日本国内で働く外国人起業家にとって、それがいかに重大なリスクであるかを示すものと言えます。
And next, I would like to turn to my other part briefly, which is about the SMBC Nikko Securities market manipulation incident. And that follows from mandatory investigation made by the Securities Exchange and Surveillance Commission. And following this, again, investigation made by the Tokyo Public Prosecutor's Special Investigation Division led to the arrest and indictment of executives Trevor Hill and Alex Avagans. These two cases, particularly with regard to the detention of Mr. Gon, which was severely criticized by the working group of the Human Rights Commission of the United Nations with regard to arbitrary detention, it essentially shows how serious a risk it is for foreign executives to work within the nation of Japan, along with the pre-modern tendencies of the Japanese criminal justice system.
まず、ケリー判決についてお話をしたいと思います。この裁判では、ゴーン氏、ケリー氏、そして、秘書室長の大沼氏が、犯罪行為者とされ、3人の共謀によって、禁商法違反の犯罪行為が行われたとして、法人としての日産も起訴されました。
Let me start with the Kelly decision. In this trial, Mr. Gon, Mr. Kelly, and the head of the Secretariat, Mr. Toshiaki Onuma, were alleged to be the perpetrators of the crimes. And there was a conspiracy among the three. Charges of criminal activity in violation of FIEA, as well as Nissan indicted as a corporation.
第一の争点は、ゴーン氏が2010年度から17年度に実際に支払いを受け、有価証券報告書に記載して開示した役員報酬以外に、開示すべき未払いの報酬があったのか否かです。この点が否定されれば、ゴーン氏、ケリー氏、大沼氏の3名共謀による犯罪行為そのものが否定されるので、ケリー氏、日産自動車が全面無罪となるだけではなく、ゴーン氏も仮に日本で裁判を受けた場合には無罪だったということになります。開示すべき未払い報酬が存在するとなった場合には、それを開示しなかったことについて、有価証券報告書虚偽記載の犯罪の成否が問題になります。
So the first dispute in the Kelly decision that was rendered recently, first dispute was whether Mr. Gon actually received certain payments between the years 2010 and 2017, and whether there was unpaid remuneration that should have been disclosed beyond the executive compensation that was disclosed in the annual securities reports. If this point was negated, then the conspiracy and criminal charges against Mr. Gon, Mrs. Kelly and Onuma would be negated, which means not only would Nissan Motor and Mr. Kelly be fully exonerated, but Mr. Gon would become essentially acquitted if he were to receive trial. Now, on the other hand, if it was determined that there was unpaid remuneration that should have been disclosed and that it was not disclosed, then the question would be whether the criminality would be established under false statements in the annual securities reports.
第二の争点となるのが、ケリー氏が開示すべき未払い報酬について認識していたのか、そしてそれを開示しないで有価証券報告書に虚偽記載を行うことについて、ゴーン氏、大沼氏らと共謀が認められるかどうかです。この点は、ケリー氏個人の経営責任に関するものであって、その点で、ケリー氏の経営責任が仮に否定されても、ゴーン氏の経営責任を否定することには必ずしもつながりません。ゴーン氏や大沼氏を犯罪行為者として日産を有罪にすることができるということになります。
Now, the second dispute relates to Mr. Kelly himself as to whether he was aware of this so-called unpaid remuneration that should have been disclosed. And with regard to whether there was a conspiracy that could be recognized along with Mrs. Gon and Onuma with regard to false statements in the annual securities reports because of non-disclosure. In this regard, this would be the personal criminal liability of Mr. Kelly. And so if the criminal liability of Mr. Kelly in this matter, regarding this point, was even if this was negated, it would not necessarily negate Mr. Gon's criminal liability, and it would not necessarily lead to that conclusion. Consequently, Mr. Gon and Mr. Onuma, as well as Nissan, could still be rendered essentially guilty as criminal perpetrators.
判決では、第一の争点について、2010年度から17年度分のすべての期間について、検察の主張通りに開示すべき未払い報酬があったことを全面的に認め、第2の争点については、ケリー氏には最終年度の2017年度分については開示すべき未払い報酬の認識があり、ゴーン氏、大沼氏との共謀も認められるとして有罪、2010年度から16年分については認識がなかったとして無罪としました。
With respect to the decision most recently handed down, with regard to the first dispute, as far as the periods running from 2010 to 17, the court found for the prosecutors, as they alleged, that there was unpaid remuneration that should have been disclosed. This was fully recognized in the decision. But with respect to the second dispute, as far as Mr. Kelly goes, they determined, that is, the court determined that Mr. Kelly was aware of unpaid compensation or remuneration that should have been disclosed for the final year of that span, which was the year 2017, as well as conspiracy with Mr. Onuma and Mr. Gon. Therefore, he was handed a sentencing of guilty for that year. But for the years running from 2010 until 2016, the court found that he was not aware of anything relevant for those years, and he was acquitted.
この判決結果のうち、ケリー氏に対する判決結果の方に、注目が集まってますが、私は最大の問題は、この第一の争点、ゴーン氏についての有罪を実質認めた部分だと思います。
Now, there's been much media attention and focus on Mr. Kelly's decision and the results of the court decision on Mr. Kelly. But I believe that the largest issue at hand here is actually the first dispute and the guilt that the court has rendered upon Mr. Gon.
未払い報酬について、判決はゴーン氏の受領の意思がどの程度強いものだったかについて、日産の取締役を退任した後、協業秘書やコンサルタントの契約などを締結して、退職後に行う仕事や義務に対して支払われる報酬を計算する際の参考に過ぎないと供述していることについて、単なる参考に過ぎないとすれば概算額で足りるはずであり、その額を累積額とともに、秘書室に継続的に管理され、その累積額が記載された各種文書を繰り返し作成させていたのは、単なる参考として過剰なものだと述べて、ゴーン氏の供述を信用できないというふうに判断しました。
So, with regard to the unpaid remuneration, the court decision looked at how strong Mr. Gon's intent was to receive that. Mr. Gon has stated on the record, after I retired from Nissan as a director, I would enter into a non-compete or a consulting agreement, and therefore there would be compensation paid to me with respect to the work and duties that I would be borne with after retirement. And this was therefore merely a reference in computing that remuneration. The court said, if this was merely reference, then it should have been just estimates in terms of the amounts. Instead, those amounts were accumulated and continually managed at the Secretariat, and that those cumulative amounts were repeatedly noted and made evident in preparations of various documents. That is excessive in terms of the characterization of just mere reference, and therefore the court found that Mr. Gon's statement could not be relied upon.
しかし、ゴーン氏は報酬を受領する意思は全く否定していません。未払い報酬となった金額について、合法的に受領が可能な範囲で受領しようと考えていただけです。もし合法的に受領できないのであれば断念するしかないと思っていたということです。判決がゴーン供述が信用できないとした点は全く理由になっていません。
Mr. Gon, however, has never denied at all that he had an intent to receive this remuneration. With regard to the unpaid remuneration, he had thought all along that he would receive it within the range that the receipt could be done legally. If it could not be received legally, he felt that he would have to probably abandon that effort. Therefore, this decision where the reasoning is Mr. Gon's statement cannot be relied upon is not a reason at all.
この点について判決は、実質的な争点は日産が開示すべきであった報酬がゴーン氏が主張するように、実際に支払われた金額なのか、それとも検察官が主張するように、実際に支払われた金額に未払い報酬を加えた総報酬なのかという法解釈の問題につきます。この点について判決は、会社に対する権限規定に基づいて、取締役の報酬額について決定する権限を有する者が、会社の所定の手続きに従って取締役の報酬額について決定し、会社の所定の部署において取締役の報酬が継続的に管理されているのであれば、会社としては当然にその取締役の報酬額を開示すべきであると判示したわけですが、なぜそのような報酬について開示すべきなのか、全く理由を示していません。
In this regard, the actual dispute turns out to be, as Mr. Gon alleged, the so-called remuneration that Nissan should have disclosed. Is it the actual amounts that were dispersed and paid, or is it, as alleged by the prosecutors, the actual amount actually paid plus the unpaid remuneration, as in, therefore, the total, the grand total? This is where the issue lies in terms of the legal interpretation. In this regard, the decision of the court has stated that that person who has the authority to decide remuneration amounts of directors based on the authority delegated to that person by the company, in accordance with the prescribed procedures of the company, makes those decisions on the amount of remuneration for the directors. And if those remuneration amounts are continually managed for the directors at a prescribed department within the company, then the company naturally should disclose those remuneration amounts of the directors. That is what was stated in the decision. But there is not any reason whatsoever as to why that remuneration should be disclosed.
そして開示すべき報酬について判決のように考えることで多くの点で論理が破綻しています。まず一つは、会社法上違法な報酬であっても金商法上開示義務があるとしている点。2番目に、所定の手続きである他の代表取締役との協議が必要とされているのに、それを行っていなかった。そういう報酬でも開示義務があるとしている点。
Now, conversely, if we think about what should have been disclosed as compensation or remuneration, the logic of the court's decision in many parts is falling apart. Number one, the court said, remuneration deemed illegal under the Companies Act still must be disclosed. There's an obligation or duty to disclose under the FIEA, Financial Instruments and Exchange Act. The court said this. Number two, the court notes, even for remuneration that did not entail consultation among other representative directors, which was the prescribed procedure, there is a duty to disclose this remuneration, the court says. Number 3, the language of the annual securities reports of Nissan clearly states, quote, paid or dispersed compensation. This obviously does not include unpaid remuneration. So it is not a false statement. There might be a duty to disclose, but it would merely be a non-statement or a failure to state.
これらの詳細については、私が論座に、投稿して、セスリームス氏に訳してもらった記事に詳細に書いておりますので、そちらをご参照ください。実際に言い渡された判決は、法解釈を逸脱し、文言解釈を無視してまで未払い報酬の開示義務を認め、なりふり構わずゴーン氏有罪の結論を導くものでした。その判決の内容を見る限り、この裁判所で審理を受けるはずだったゴーン氏が、保釈中に国外逃亡を敢行し、現在もレバノンにいて日本の刑事裁判を拒絶していることへの反感も背景になっているようにも思います。国外逃亡したゴーン氏に代わって日本で裁判を受けたケリー氏に対する判決で、ゴーン氏の逮捕事実の禁止法違反について下された判決は、まさに日本の刑事司法に重大な汚点を残すものだと考えられます。
Further details about my analysis here, you can refer to the electronic medium Ronza. I wrote it in 2 parts. It's also been translated by Seth Reams into English, and it should be have been distributed. So I will render more details to your reading. Let me continue. Now, the actual sentence that was handed down deviated from interpretation of the statutes and even ignored literal interpretation to recognize disclosure obligation of unpaid remuneration to derive a conclusion of Mr. Gohn's guilt with no regard to appearances. I'm sorry, I'm reading from the Ronza because this is a summation from the Ronza toward the end of part 2. As far as I can tell, the content of the decision also seems to portray ill will toward Mr. Gohn, who was supposed to stand trial at this court, but instead bravely executed escape outside Japan while on bail, and continues to stay currently in Lebanon. Rejects a trial in Japan. So, on behalf of Mr. Gohn, who fled outside of Japan, Mr. Kelly was faced trial, and in his decision that he received, the decision that was handed down with respect to the violation of the Financial Instruments and Exchange Act under the charges of arrest for Mr. Gohn, have left a serious, dirty mark on Japanese criminal justice.
次に Smbc 日興証券事件の関係ですが、この事件についての問題点の一つは、起訴事実が金商法159条3項の安定捜査にそもそも該当するのかという事実関係の問題、それとそれについて範囲、共謀があるのかという問題です。
Now turning to the Smbc Nikko Securities incident, one of the issues with this matter is whether the charges that were brought in the indictment with regard to Article 159 of the FIEA really point to whether there really was some sort of stabilization being manipulated or not, and whether there was any criminal intent or conspiracy.
安定捜査取引とは、有価証券の募集や売り出しを円滑に行うために、相場の安定を目的として行う市場での売買取引であり、届け出、報告等の所定の手続きによって行われる場合には適用とされますが、そのような手続きを経ることなく、株価が一定期間、上限価格と下限価格の間の一定の範囲から逸脱しないようにするための安定捜査が行われた場合には、違法ということになります。
With regard to the facts, so the so-called stabilization or manipulating to stabilize, I might translate it as, is with regard to essentially trying to stabilize the market when you are essentially bringing securities to market, or if you are having an offering of securities. So it's permitted if you make the appropriate filings and reportings, and then it becomes legal in terms of that effort. But if you don't do any of those procedures, if you essentially manipulate to stabilize a share price between an upper limit and a lower limit, so it doesn't leave that range for a prescribed amount of time, period of time, then it's considered illegal.
本件ではいくつかの会社の株式について、ブロックオファー取引が予定されている特定の日に、終値に近い時間に指値買い注文を入れて、終値がその価格を下回らないようにしたというものですが、そのような単発的な行為が安定操作に当たるのかどうかは疑問です。また、相場を安定させる目的を持って、一連の有価証券売買を行うことについての範囲と共謀なのですから、どういう銘柄について、どのような目的で相場を安定させるのか、価格をどのような範囲に安定させるのかについての認識を共有することが必要です。買い支えを行うことについて漠然と認識していたという程度では、範囲共謀があったとは言えません。そういう範囲共謀があったのかどうかも疑問です。
So in this regard, there were several different issues of stock from various companies that were scheduled for block offer trades. And on specific dates toward the time near when the end of day price was going to be set, there would be a buy order put in at a specific price. And it was essentially an effort for that price to be maintained at the end of day trading price so that it didn't go below the order. So the first question is whether that type of spot-basis activity is really considered to be stabilization. And essentially, the criminal intent and conspiracy relates to having some sort of purpose to stabilize the market and then to engage in a series of trades of securities. So there has to be a common awareness in terms of which stock issues we're talking about, what purpose is for the stabilization of the market, and what's the price range that you're going to stabilize at. If you just have some sort of vague understanding that you're going to buy to support a price on the market, I don't think you could say there's any criminal intent or conspiracy. So there's a question there's a big doubt here or question as to whether the indicted Smbc executives really had any criminal intent or conspiracy on their mind.
もう一つは、本件で適用された安定操作を禁止する日本の金商法の規定自体に問題があるのではないかという法律自体に関する問題です。
The other matter is just an issue relating to the statutes themselves. There seems to be potentially a problem with the stipulations themselves within the FIEA of Japan that prohibit stabilization.
日本の安定操作に関する規定は、米国証券取引法商法9条 A 項6項の規定がそのまま日本法に導入されたものです。制定当初は、アメリカ証券取引法と同様に、有価証券の募集または売り出しの際の安定操作のルールを規定するものでしたが、71年の制定改正で、当時の大蔵省証券局の独断で処罰の範囲が拡大され、現在の規定のように、有価証券の売り出し勧誘を容認するために行う安定操作は、一定の手続きを取ることで適法とされるが、それ以外の場合は、安定操作自体が一律に禁止されています。しかし、相場操縦の犯罪性の本質は、他人の売買取引を誘引することにあるのであり、相場を変動させることは、その重要な要因となる、相場を、その重要な要因となる相場を安定させるのは変動させるのとは異なって、他人の取引を誘引する効果は希薄です。変動操作のように他人を売買に引き込んで自分は売り抜けるという目的も考えにくい。また、そもそも法律改正によることなく、政令改正で処罰範囲を拡大すること自体にも重大な疑問があります。つまり、日本の金商法の安定操作に対する罰則を適用したこと自体に重大な疑問があり、究極的には憲法が保障する財形法定主義にも反するのではないかという問題がある事件です。
Now, with regard to this, the problem with the statutes themselves, the regulations regarding stabilization in Japan are essentially directly imported into Japanese law from the U.S. Securities and Exchange Act, Article 9, Section A6. At the initial establishment of the law in Japan, it was similar to the SEC Act, Securities and Exchange Act, not SEC Act, Securities and Exchange Act of the U.S. And it was primarily to essentially stipulate rules for stabilization in terms of when you did stock offerings or stock sales on the market. But the cabinet order revision in 1971 in Japan, this was done essentially at the Securities or Securities Bureau of the Finance Ministry on essentially their sole pretenses at the time. They enlarged the scope of punishment to the current regulations, where it says that it's illegal as long as you have prescribed procedures for stabilization to facilitate the selling and offering of securities. But in any other case, stabilization is essentially completely uniformly prohibited. Now, we look, though, at the essence of criminality in terms of market manipulation, and that relates to when you're trying to induce people to trade. You're trying to induce others to trade on the market. Now, the important factor here is different. That relates to causing fluctuation in the market, as opposed to what we're talking about here, which is stabilizing the market, which is which pales in terms of the effect that it might have in terms of inducing others to trade. And therefore, it's also, like in manipulations you might do to fluctuate pricing, that's really, an inducement where you get other people to trade, and then you take advantage of those people trading, coming into the market, and then selling your securities to make a profit, and they get on their, onus. So that's why the purpose here is hard to think that there's anything relevant in this regard to stabilization. Also, they made a revision as a cabinet order back then, which was not a statutory revision of the law. And then expanding the punishment just with the cabinet order revision, that is also a big question mark in my mind. So in essence, when you're trying to punish stabilization under Japan FIEA, there are a lot of questions, and ultimately there's a possible violation against the Constitution, which is safeguards against essentially statutory principles in terms of the form of criminal punishment.
以上です。
Okay, thank you very much, Mr. Gohara. So we're going to go to Q&A. It's 35 past, so we're going to start with people on the floor. Let me just ask a first question to begin with. Mr. Gohara, you explained to us what the problems are with those allegations and arrests. Why are they doing it? I mean, why are Securities Exchange Surveillance Commission or the Special Investigation Unit of the Tokyo Public Prosecutors, what their intent? Is that targeted at the foreign corporate executives in particular, or is it that it's been done that way to the Japanese corporate executives, but now that it is extended to the foreign corporate executives as well? Is that the situation? That's my question. 自分に言おうか。ゴーラさん。
どうしてもいいですよ。
じゃあ、I'll leave that to you.
じゃあ、ゴーラ先生、私の方から早速質問させてくださいね。今回の一連の問題や逮捕についてのご説明ありがとうございます。結局ですね、私が知りたいのはですね、この、証券取引委員会じゃなくて何ですか、監視委員会ですか。
証券取引監視委員会。
はい、こちらの委員会の方と東京特捜部は一体何を、正直考えてるんでしょうかね。何が目的なんでしょうかということと、そしてその中で特に思ったのは、なんか外国人の、企業の幹部の方を、告発逮捕するっていうことに
対して何か特に何か意図があってなのか、つまり今までは日本の会社で日本人のそういう企業幹部の方にかなり軸を置いてですね、検挙していたところから、なんかその外国人に軸を移したのか、拡大したのか、何かその辺はあるんでしょうか。
つまりこれは今まで日本人には適用されてたんだけど、外国人はこれまでは適用されてなかったものがここに来て外国人にも適用されるようになったということなのか、それとも外国人を特にターゲットにしたものというふうに考えるべきものなのか、そういうことです。はい、
これまでにも日本人に対しても同じようなこういう不当な逮捕・起訴、そして不当な判決が出されるというケースは多々あったと思います。でそれがそういう非常に問題のある日本の刑事法、特に経済事犯などについて問題のある刑事法が今回立て続けにですね、外国人の経営者、ビジネスマンに対するリスクとして顕在化したということだと思います。
Well, up until now, there have been a litany of Japanese executives who have been unreasonably arrested, indicted, and handed down court decisions. Many up until now. I think what happens here is that we've had a series of these economic, criminal cases, so to speak, lately, and it's just manifested in itself that foreign executives and foreign business people have also been caught in this web.
以上ですか。はい。Okay, all right. Let's go to the floor. Okay, so why don't you go first, and then.
小原先生、おはようございます。よろしくお願いいたします。My name is Richard Susilo from Tribune News Indonesia. Very simple question. I'm not entering the problem. I'm entering, need your advice for foreign executives who would like to enter Japan. So what is the most important for the foreign executive to enter Japan to become very good? They work slowly and they work smoothly and without a problem in Japan. Because I believe every country has their own character, their own way of thinking, and everything. So to learn the culture of each country, they have to learn Japanese language in Japan. That is the basic, I think. So without this Japanese language, they could not understand the culture. But some of them, they are too proud for themselves. I'm the president, I'm the director, how should I learn Japanese language? I'm not living in here. So actually, what is the most important for the foreign executive to become a good foreign executive in Japan? Thank you.
どうも、私、インドネシアのトリビューニュースのリチャードと申しますけれども、質問させてください。基本的に知りたいのはですね、海外の企業幹部が日本に来てですね、仕事を進めるにあたって、最も重要な要素は何になってくるでしょうか。つまり、問題が起こらず、スムースに生活して、仕事をするというのはどうしたらいいか。どの国も特徴があり、その国の中での思考プロセスというようなものがあって、文化があってですね、例えば基本で言うと、やはり日本に来る以上、日本語を覚えるということが挙げられるのではないかと思います。日本語を覚えると、今度は日本の文化についても、学べるという、そういうリンクなんですけれども。ただ、外国人のエグゼクティブは非常にプライドが高いし、社長とかトップになってみては、もうどのようにしてこんな日本語を学べって言うんだって言うんですね。しかも別に長期間日本に住むわけではない。そういうこともあるので、ぜひどうやって、この海外のビジネスマンは日本でスムーズに生活すればよいか教えてほしいんですが。
外国人経営者ビジネスマンが日本で今回のように犯罪に問われ検察に逮捕されたりした場合ですね、言葉の問題などもあってその自分の権利を守ることが非常に難しい状況に追い込まれます。やはりそういう意味ではですね、私は日本にで仕事をする外国人の側にももちろんその注意をしてもらわなくちゃいけないとともに、そういう外国人にとっても不当な逮捕起訴 にさらされることがないような刑事司法、私に言わせればもっとまともな正当な刑事司法に変えていかないといけない。それを日本国内からはなかなかそういう力が働かないんで、海外の世論も含めてですね、日本の刑事司法の全近代性を批判をしていくことが必要なんじゃないかと考えています。
Well, what happens in certain unfortunate situations is you have foreign senior executives and business persons who are charged with crimes. They're arrested. And all of a sudden, they have a language issue. And because of the problem with language, they have faced an extremely challenging position in protecting their own rights. So we should be cautioned if we are working as executives who are non-Japanese here in Japan. But on the other hand, the criminal justice system needs to consider the unreasonableness in terms of the way the arresting and indicting is processed. In my mind, we need to institute proper criminal justice procedures in Japan, which are not in existence right now. But the forces within our nation are not strong enough to insist on this. And therefore, I think we need to do this outside-in approach that could perhaps help this get moved along.
一つ例を挙げるとですね、カルロス・ゴーン氏が逮捕、された際、日本の人質司法に対して、国際的な批判が高まりました。で、今回この SMBC 日興証券の事件もこの起訴された2人の外国人にとってはもう大変な苦難だと思いますが、幸いなことにですね、今回全面的に否認をして徹底的に検察と争う姿勢を示しているのに、裁判所は保釈を許可しました。この検察は徹底して保釈に反対しても裁判所が許可をするという姿勢になったというのは、これはやはりカルロス・ゴーン事件での国際的な批判、人質司法に対する国際的な批判があったからじゃないかと考えています。
For example, Mr. Carlos Ghosn, when he was arrested in Japan, he was subjected to hostage justice, and there was a storm of criticism internationally. Now we come to the Smbc Nissan case. Now, I'm sure it was a tremendous travail for the two foreign executives who were indicted and, of course, arrested before that. But I think we can also say that there's some good fortune here in the sense that these two executives said that they would fight this, all charges, 100%, and they absolutely denied all of the charges. Now, this would be a very much of a predicament up until now, but we find that they have been released on bail. It is evident that despite the public prosecutor's emphatic effort to keep them detained, the courts are now allowing for people to be released on bail prior to their court dates. And this is clearly, I think, a shift that I think resulted from that heavy international criticism with Mr. Ghosn previously.
Okay, right. By the way, one of the benefit of coming to the press conference in person is actually you get to meet people. Of course, you get to meet Gohara-san, but in the audience we have Mr. Akio Kawamura. Kawamura 先生、すみません、ちょっとご紹介だけさせてください。He actually represents the two executives of Nikko SMBC case. And he's a lawyer in Japan, and also he's attorney, registered attorney in New York state of New York. So, 終わってもしばらくおられます、河村先生。もしおられれば、if you wanna go and exchange your meishi, he's there. Okay, you wanna take the questions? Yes? Okay, go ahead.
Hello, Hans Greimel from Automotive News. I have a two-part question that's focused mostly on the Ghosn case. In the Ghosn case, one of the mysteries that wasn't explained in court clearly was the nature of the plea bargain from Nada and Onuma. Under their plea bargain, they must have agreed or assume some guilt for some kind of breaking a law. Do you have more details have you seen the plea bargain papers? What is it that they are confessing, or to what law are they breaking? What is the kind of guilt that they are confessing to? The second question would be about the red notice against Mr. Ghosn. What can be done, or what is being done, to lift that red notice, the Interpol red notice against Mr. Ghosn, and how long can that take?
私、オートモーティブニュースのハンズ・クロメルですけれども、2つのミステリーについて質問します。両方ともゴーン氏の事件の件です。1つは名が司法取引です。灘市、大沼市が司法取引に応じたというような理解なんですけれども、その場合は当然何かの罪を認めて、そのことについて自供したというふうな流れが当然だというふうに思うんですが、そのことに関しての書類などをご覧になることはできましたか。自供はどういう内容で、そもそもどういう犯罪事実だったのでしょう。そして2点目のミステリーが国際指名手配とその取り下げなんですけれども、これについては一体どういう状況で、どういう努力が払われているのでしょうか。
1点目については、私もミステリーだと思います。そして、その司法取引の合意の内容の文書がどういうものであったのか、これは、判決の中では出てきません。ですから分かりません。ただいずれにしても、この司法取引が行われたと言われてますけども、どう考えても今回の禁商法違反事件、有価証券報告書の虚偽記載罪について、この2人が、大沼氏、灘氏が、犯罪を犯したという認識を持ってたとは考えられません。ですから、これは日産の経営者側の、ゴーン氏を処罰してもらおうと、検察に逮捕して処罰してもらおうとする、戦略の一環として、この2人の司法取引をさせたという、弁護側の主張が正しいと思います。それから2点目の国際手配の関係ですが、この国際手配に対して、ゴーン氏の側で、何らかのですね、その異議の申し立てなどをしているんじゃないかと思われますが、ちょっとそこの点は私は直接関わっていませんので、どのようなことが行われているかは分かりません。ただ私がその国際手配ということに関して、この件で問題にしたのは、むしろですね、キャロル氏、ゴーン氏の夫人のキャロル氏に対する逮捕状、国際手配が行われたことです。これは、もし本当に逮捕することが目的であれば、密かに国際手配をして、アメリカに入国するときに逮捕していればいい話ですから、それをわざわざ公開をして、国際手配をしたということをアピールしたというのは、公表したというのは、これは逮捕が目的ではなく、このゴーン氏の妻の逮捕状を取ったことをアピールしたいという検察の一つの策略だと考えています。
With regard to the first part of your first question, you said about the plea bargain, it is also a mystery in my from where I am. You know, as far as the plea agreement, it wasn't mentioned in the decision, so I really don't know. But if we think about this, you know, in terms of any criminal intent that, you know, Nada or Onuma might have had with regard to making false statements in annual securities reports in violation of the FIEA, it's unthinkable that they had any, you know, intent when in the course of their work. It seems like they were just sort of forced, as the defense counsel raised or alleged, by Nissan's corporate management as a tactic or strategy to get Mr. Ghosn arrested and penalized. And with regard to the red notice, I don't really know about what's going on with Mr. Ghosn and his efforts, if there are any on his part, to try to, you know, reach out to the authorities to get that lifted. I'm not involved in anything with that regard, so I don't know and I can't comment or say anything about it. But I should note that I should note that with regard to red notice, there's one out for Mrs. Mrs. Carol Ghosn. And this was an international arrest warrant that went out from Japan. Now, if they were really intent on arresting Mrs. Ghosn, they would not have publicized the fact that they'd have this out. Because what they would have done is kept it quiet. So when she made a trip, say, to the United States, they would have arrested her on the spot. And then she would have been arrested, which, if that was their purpose. Clearly, it's the publicity stunt aspect here. So they weren't trying to arrest her so much as to get this publicized. And I think it's another one of the schemes by the public prosecutors in Japan.
Is the content of plea bargain released? I mean, is it a public record, or have you actually seen the agreement between the prosecutors and those Onma-san and Nada-san? 司法取引の合意内容というのは公表されているんでしょうか。それからまた、第三者やあるいは小原さんはご覧になっているんでしょうか。
司法取引による供述を、証拠請求する際にはその合意書も証拠請求しないといけないということになるはずです。ですから大沼氏、少なくとも大沼氏について合意書が証拠請求されているはずなんですが、
弁護人から、
いや弁護人じゃなくて検察官がその証拠を請求する際に、そのどういう合意内容であったのかということについて判決の中でちょっとあまり詳しく書かれてなかったんです。これよくわかりません。
Yeah, in order to get your hands on plea bargains and the writings of those, you have to make the demand, but then it's within the agreement of the person who agrees to the plea bargain. So in that regard, the prosecution was able to probably obtain the document, but otherwise, I don't know how.
Okay, so it's another mystery. Okay, any questions from the floor? Okay, while you guys think about the next question, I have one question came in online. This is from Roger Streffler of Asia Times. He's one of the guys who is on top of this news among our colleagues at the FCCJ. In the Kelly case, we've uncovered evidence that Nissan on the Tokyo prosecutor's office, or both, concealed key evidence from Kelly's lawyers. July 3rd, 2019, Latham Watkins interview with Nada, in which Nada admitted that Kelly said there was no legal obligation for Nissan to pay Ghosn. Christian Murray's in-house investigation received the document in July 2019. I sent this document to you this morning. I guess this is to you, meaning Gohara-san. Sorry, Gohara-san. What are the legal consequences for Nissan or the prosecutor's office? And it had to be one of them for suppressing key evidence. It's probable. Can they be charged under the Article 104 of the Penal Code? Can you translate it?
I'll try.
Okay.
ロジャー・シェフラーさん、アジアタイムズの記者の方から今、オンラインで入ってきているので質問です。ケリー判決に関しての証拠抑制の問題ですね、日産と東京の検察局の方でですね、レイサム&ワトキンスがハリナダの方を面談しててですね、2019年7月3日に。その時にハリナダがその時に供述しているのが、日産はゴンさんにお金を払う法的な義務は一切、存在
しないとケリーが言っているというふうにナダが言ったと。
ということですね。はい、でこの書面は実はユーに送ったということで、シェフラーさんが言ってるので、ユーっていうのは郷原さんに今朝送ったっていうふうに言ってるんですけども、そういうことで日産と検察の方が証拠を、隠蔽じゃないんですけど、抑制した、出し控えたっていうことは、刑法の104条違反にならないですか。この重要な証拠書類なのに、それを要はその証拠について出さないことによって、
証拠を隠した、
つまり、そうですね、
隠蔽なのか分からないですけど、要は持ってるのにそれを裁判で出さなくて、非常に重要な。
出していないと、ケリーさんが、ゴンさんに支払い義務はないというふうに認識していたという証言が証拠としてあるのに、それを裁判で出していない、自分にとって不利な証拠を出していないということは、罪にならないのかと、そういう質問です。
そういえばそういう文書の提供をつい昨日でしたか、受けたことは間違いないんで、ちょっとよく中身を検討しようと思っているところです。で、今言われたような内容であるとすると、重要な検察官が主張する事実に対する消極証拠ということですから、それは、検察官は通常そういう証拠を自分の方からは請求しないことが多いんですけれども、それは弁護人の側にもし開示されてれば、弁護人の側から消極証拠、起訴事実を否定する証拠として出される可能性があります。問題はそれが弁護人の知るところになってないのかどうか、そこがちょっと不明なんで、ちょっと何とも言えないところですが、いずれにしても検察官は証拠を提出するかどうかということについての裁量が認められていて、で検察官が検察官にとって不利な証拠を手元に取得したからといって、それが刑法の104条の犯罪になるということは、日本では問題されたことはありません。
First of all, to the person who asked the question, Mr. Sheffer, I acknowledge receipt, but I need time to digest what you have sent over to me. And if it is true, as you now say in your question, this is passive evidence, 消極証拠ですよね。So the prosecutor, incidentally, is rarely in a position of demanding that any evidence that would be disadvantageous to the prosecution side to be, released for trial, for the documents that would be evidence for trial. And if the defendant, and this is the question, therefore becomes whether the defense was essentially aware and had received disclosure of the existence of this kind of evidence. But as far as the law goes, the prosecutor has discretion over what kind of evidence is going to be brought forth from their side. And so if they just kept certain evidence in confidence and didn't provide it for the trial, there's no, it's been essentially established in the system that this is not considered something that the prosecutor can be charged with.
Okay. Right. If there's no more questions, let me just follow up in the very end. My very first question. 小原さん、最初の質問で、外国人にターゲットにしたものかどうか、伺いました。これはそもそもなぜの部分がちょっとお答えいただけるのか、なぜだと思われるのか、つまり検察や証券等取引監視委員会がなぜ外国人を標的としたこのような法の適用をここに来て行っているのか、そのどういう意図、あるいは政治的なものも含めて背景があると思われるのか。I just asked him that kind of follow-up question to my very first question, because he didn't answer about why, as to why do you think the prosecutors and the Securities Exchange Surveillance Commissions are now all of a sudden beginning to apply this strict interpretation of the corporate and the financial law to the foreign corporate executives. Is there any political intent, or is there any background as to why this is now happening? なぜなのかについてお願いいたします。
特に外国人を標的にしている、狙い撃ちにしているとは思えないですね。そうじゃなくて、これまで日本人に対してやってきたことと同じことを、外国人に対してもやろうとしているということだと思います。で、日本人の場合はこれまで、検察と争うことが、自分にとって結局利益にならないということで、意に反する逮捕や起訴に対しても受け入れる傾向が強かった。人質司法という悪弊の下では、もう本当に自分の権利、無罪主張をとことん 行っていくと、大変なその負担になるということで諦めることが多かった。外国人だからそういう日本の常識が通用しないで徹底的に争い、それが問題になっているということが言えると思います。
Well, I don't think foreigners are necessarily the targets, and I don't think they're like taking aim specifically and shooting at only those foreigner executives. I think the same has been happening over the years with many, many Japanese executives. And now it's kind of highlighted in the sense that they're going after foreign executives also, as well as the Japanese. But here's the interesting thing. The Japanese executives, they get arrested, they get detained, and they don't fight the prosecution because they are made aware that there's no merit in fighting the system. Even if they are essentially put with basically different intentions or different views in front of them that they have to acquiesce to essentially work through the system. And again, the huge burden that you are essentially made to bear to clear yourself, to prove your innocence, they give up. And this is the common sense, Japan way that people have been kind of trained into. But the foreign executives are different. They don't have any of that baggage, so they're going to fight tooth and nail.
じゃあ日本人だったら通常争わない場合が多かったと。You have to prove your innocence in Japan. Okay, the very last question. This is going to be it. It just came in online from Karin Nishimura of Radio France. Don't you think it's becoming more and more difficult to say that Mr. Ghosn has done nothing wrong, as there are also strong wrongdoing suspicions in France and arrest warrant from French prosecutor. いいですか？じゃあお願いして。はい。
最後の質問が、ラジオフランスのカレン西村から来ています。郷原先生。状況はしかしますます困難になっていませんか？ゴンさんが何も悪いことをやってないと言いにくくなっているはずです。フランスで、嫌疑がさらに取り沙汰にされ、逮捕状も出ていますよ。どうですか？
フランスでどのような容疑で逮捕状が発布されたのかということは、私は詳細は把握をしていません。この件については、ゴーン氏が CNBC のインタビューを受けて、ゴーン氏としての説明を、今の見解を語っています。この CNBC のインタビューの方をご覧いただければと思います。
I do not know what the charges are with regard to this so-called arrest warrant that was issued in France. Incidentally, I would mention that CNBC interviewed Mr. Ghosn at length, and Mr. Ghosn has explained some of this, I think, in that interview, and it can be, I think, accessed. So I would encourage you to turn to that interview.
ただ、少なくとも言えることは、日本の逮捕状がですね、先ほどキャロルさんに対する逮捕状について、お話したように、私は全く不当な、国際手配だと思うんですが、そういったことに関しても、不服を申し立てる、どんな理由で逮捕状が出たのかということを確認する手立てすら、ないのと違って、フランスでは、そういう推定無罪の原則が働いて、逮捕状が発布されたことに対しても、被告人側のディフェンスを行う余地があるということで、ある意味では今後、事件の内容が表に出てくると、きちんとその当局の側の嫌疑の内容にもアプローチできるということで、前向きに捉えている面もあるように、少なくともこの CNBC のインタビューからは考えられます。
Unlike the arrest warrant issued in Japan, like I said, there was an international red notice sent out for Mrs. Ghosn, Carol Ghosn. which I believe is totally unreasonable. There's no way to understand further what the reasoning behind these warrants issued are, even if you're unhappy with what's happening. There's no process. Now, in France, presumed innocence is alive and well, I understand, and therefore the defendant and their defense have an opportunity here for this case to finally, I think, come to light, and those suspicions can be made correctly known. So I believe there is a positive side to what you are talking about in your question. Again, this is sort of what I'm taking from the CNBC interview that I had an opportunity to see. Thank you.
Okay, thank you very much, Mr. Gohara, and thank you for coming for the press conference. I think we have to wrap up this press conference. And Mr. Gohara says that he will stay on to exchange name cards with those who are here. And like I said, Mr. Kamara is among the audience. So again, thank you for coming to press conference. Meeting's adjourned.